prosecutor approach the witness.
Thank you, Your Honor. Mr. Kendrick, is it true that you had an accident on April 9th of this year?
Yes, sir.
After your accident, did the defendant approach you?
He did, yes.
Did the defendant say anything after he approached you?
Yes, the defendant apologized to me. He said that he was adjusting his radio to 409.0 AM talk radio, and that he did not see me, and he offered to pay for my medical expenses at that time.
Objection!
On what basis?
Rule 409 states that offers to pay medical expenses and other similar expenses are not admissible to prove liability.
I'd like you to say Your Honor before you address the court like that.
Excuse me, I'm sorry, so sorry.
All right, so what's the probative value here? Our gentleman was not paying attention to the road. So you're saying?
That's what he said.
Okay, but the rule says that liability cannot be proven through offer to pay for medical expenses. I'm going to overrule and allow this. I think the probative value of playing with the radio outweighs any prejudicial qualities from the offer to pay for medical expenses. So you can go ahead, counsel, proceed with the witness.
Thank you, Your Honor. No more questions.
All right, let's take a look at Rodman v. Bale. This is diversity action in which the defendant is appealing the trial judge's decision allowing an offer to pay medical expenses. The defendant was playing with his radio at the time, turning it to 4:09 a.m. He was found liable for $409,000. The court reporter put together this lovely record for us. And the defendant's attorney timely objected as per Rule 103 and reserved it for appeal.
So what evidence was offered at the trial, and why did you overrule it?
The evidence that was offered was that after the accident, the defendant offered to pay medical expenses and also said that he was sorry that he was playing with his radio or something of that sort.
Interesting, because the comments actually mentioned that this rule doesn't extend to conduct of statements, so it appears that he could have admitted the evidence of guilt, admitting guilt, but the evidence of payment of medical expenses, offer of payment of medical expenses, should have never been admitted. Should have been excluded.
We gotta look at the policy justifications for Rule 409. The policy justifications are, not to prevent people from acting on their humanitarian motives. Rather, they're in place to get people. It's socially desired for people to actually pay for post-medical care and help out with that.
Exactly. So it should have been excluded.
I see. So then it would seem that the trial judge erred in allowing the medical expenses, but it was not an error to allow the defendant's other statements about the radio. Therefore, this case should be reversed and remanded with instructions to disallow the evidence of the offer to pay the medical expenses as irrelevant, while the other statements about the radio are admissible.
Agree?
Agree?
Okay.
Okay.